Have you ever wondered who gets to decide who serves as a judge in our federal courts, especially when their decisions can impact us for decades? It is a fascinating part of our government's design, ensuring thoughtful leadership in the judicial branch. The Senate's constitutional role in judicial power is to provide advice and consent on the president's nominations for federal judges, including Supreme Court justices. This vital function is explicitly outlined in Article 2, Section 2 of the United States Constitution, serving as a critical check on executive authority in shaping the judiciary. The framers of the Constitution envisioned a federal judiciary that would be independent and impartial, free from the immediate pressures of politics. They understood that giving one person, the president, sole power to appoint judges could lead to an imbalance. Therefore, they deliberately instituted the Senate's advice and consent power. This mechanism ensures a collaborative and deliberative process for filling lifetime appointments on the federal bench. The advice part originally meant the president would consult with the Senate before making a nomination, though this is less common now. The consent part involves the Senate evaluating the nominee through rigorous hearings, committee votes, and ultimately, a vote by the full Senate. This careful scrutiny is designed to ensure that judicial nominees possess not only legal competence but also the judicial temperament and commitment to the Constitution necessary for such a powerful and lasting role. A simple majority vote in the Senate is required for confirmation, which is a testament to its significant power. This shared responsibility reinforces the separation of powers, preventing any single branch from accumulating too much control over the interpretation of our laws. For citizens, this means that the selection of federal judges is not a closed-door process. Through their elected senators, the public has a voice in who ultimately sits on the federal bench. It means every nominee undergoes a public examination, offering transparency into their qualifications and judicial philosophy. This process underscores the importance of staying informed and engaging with your representatives on such significant appointments. A fascinating aspect of this process involves the Senate Judiciary Committee, which plays a pivotal role in reviewing judicial nominees. It holds extensive hearings, questioning nominees on their legal views and past decisions. For district and circuit court nominees, a long-standing tradition known as the blue slip rule often allows home state senators to effectively veto a nomination, although its application has varied over time. This tradition highlights the profound influence individual senators can wield. The level of scrutiny also intensifies significantly for Supreme Court nominations, given their nationwide impact and lifetime tenure, making these confirmations some of the most closely watched events in Washington. Ultimately, the Senate's advice and consent power is a cornerstone of our constitutional system, protecting the independence and integrity of the federal judiciary. By requiring careful consideration and agreement from the legislative branch, it helps ensure that those who interpret our laws are well-qualified, fair-minded, and committed to upholding the Constitution. This deliberate process secures a judiciary that can effectively serve as a pillar of justice for all.